Before we go ahead and understand how wills and codicils are drafted, let us first understand a little bit about succession laws. So, every individual eventually lands up getting married or has a family. So, it is for this family that the individual goes ahead and works, collects money, houses, cars, and other valuable assets. Now, when that person dies and is no longer alive, uh, those assets get distributed based on either his religion or under specific instructions written by him during his lifetime. Now, in the latter case, the laws are testamentary laws, and in the former case, the laws are interstate laws. When a person dies without leaving specific instructions as to how his assets are to be distributed among certain persons, those laws are referred to as interstate laws, and those laws in India are generally governed under the Indian Succession Act 1925. And the interesting thing is that from state to state these laws might vary, and for most of the country it is under the Indian Succession Act. However, something to make a note of is that Goa has its own uniform civil code, and they have their own law as far as interstate succession is concerned. Even testamentary, to some extent, testamentary laws are concerned. Now, today we are not going to go deep into interstate laws. We are not going to go deep into testamentary laws. We are only going to look at the outset. We are only going to look at how a will is drafted. So let's get to the will. A will is an instrument by which the maker instructs certain persons on how to distribute his assets and how he would prefer his body is disposed of. So if he would like burial, or he would like his body to be incinerated, or whatever he would like. So let us look at some key factors that are involved in drafting the will. First and foremost, the mental capacity of the person, whether he is a major, whether he is capable to contract, whether he is not an idiot. Stuff like this is looked at. Sometimes you might require a doctor's certificate. It is always advised that a doctor's certificate is taken if the author of the will is over and above 60 years of age. This is only so that no dispute can be established regarding the mental capacity of the maker. In addition to this, a doctor's certificate is also taken in cases of a person who is suffering from some kind of insanity, where his periods of insanity are fluctuating, and therefore during the period of his sanity, the doctor verifies whether he knows what document he's executing, and if he's capable of understanding the repercussions of what he is executing, then that document can be held as valid. In addition to this, the date and time of execution of the document should be clearly mentioned by the author. So exactly when he is signing this document, it should be crystal clear where, when he is signing this document. In addition to the time and the location and the date of signing the document, the testator, that is the person who is signing the document, should sign with his complete authentic signature on every page, because this helps in establishing the veracity of the statements made in the will. This helps in making it more genuine, more foolproof. Therefore, it's always advised that he signs each and every page. Along with him, 2 attesting witnesses must sign the document. The role these attesting witnesses play is that they confirm that the testator has signed the document in their presence and in the presence of each other. So these witnesses are the people who would be called up in court and asked to verify whether this will was actually signed by this person or not. And therefore, it is always advised that an affidavit in support be taken. What an affidavit in support is basically a sworn statement. A sworn statement by the witness wherein he clearly states that such and such events have transpired on this date, and he has been a part of this will, and he has witnessed this person sign the will. In fact, he might even have checked whether the person knows what he's doing, and he has witnessed the execution of this document, and he's recording this most likely because he might not be around in the future, or because he is afraid that memory might fade, and therefore today on solemn affirmation he is willing to state the events that have transpired. This affidavit can be used in court in the event the attesting witness himself passes away, or in the event the attesting witness cannot recall the events of this date, or he himself is suffering from some ailment such as dementia, etc. The next thing that is required is a consent affidavit from the heirs, especially in Mohammedan law. So Mohammedan law only permits a person professing Islamic religion to bequeath only 1/3 of his property. So only 1/3 can be willed under Mohammedan law. Therefore, consent affidavit in case of Mohammedans is a must. Without this, the will itself could be defective. In addition, when you are doing a will, and if you are not a Mohammedan, then it's still advised. If you can get an affidavit from the heirs, why not get one? It makes your legal position stronger, makes the position of the beneficiaries stronger, the people who are receiving the property stronger. So it makes it clear. A consent affidavit is a simple document, it's a sworn document on which each of the heirs, the people who are receiving a property, accept that property and clearly state on solemn affirmation that they have no issue with the other documents and with what is being given to the other people, other heirs. Coming to the next topic, the will need not only mention debts, the document need not only mention assets, but it may also mention the debts and expenses. It can make it clear that the testator would like to clear out all his debts, and after clearing out his debts, the properties be distributed. He may even decide from where the debts ought to be cleared. So he might make a mention that a bank account, notwithstanding what has been mentioned in his will, a bank account number so and so is being maintained by me in order to ensure that enough funds are available at the time of my demise to meet my funeral expenses, my last wishes. So specific instructions can be given, and post deduction of all these expenses, whatever amount is remaining in this account may be given to so and so, or may it is my will that it be given to so and so. Always remember, no statements of may should be there. Like I was just saying 2 minutes back, may be given should not be the case. It should be so and so item shall be given to so and so person. It should be assertive, not questionable, not a choice. All right. Moving on. Alright, so every item that is bequeathed, it should be, it's always preferred that the testator clearly mentions why he's giving a certain asset to a certain person. If there is a reason, it's always best that that reason be expressed, because tomorrow when the heirs get up to fight with one another, it's always best that the testator's intention is clear. So if the testator say is giving a asset to Mr. Z, and the reason behind it is because Mr. Z has assisted Mr. T, the testator, in his entire life, and as a token of appreciation he's giving the higher value asset, which is A, then that explanation should fit there. There's no doubt, like there's no bar on what can be mentioned in the will. The more clarity that there is, the more better it is for the judge to understand why you are making this document, what intention you're making it with, what purpose is it to serve. Following this, there should always be a rest and residue clause. The rest and residue clause basically states that in case the testator has acquired new property after the making of this will, or in case he has forgotten something, how that excess assets need to be distributed. So in case you have purchased a new house and you haven't updated your will and you pass away, then what happens to that house? Is it supposed to be governed by interstate succession, or would you rather have it just go straight away to some person? This rest and residue clause plays an important and critical role. In the event you purchase a property or you purchase any asset and you do not mention it in your will and you do not have a rest and residue clause, what is going to happen is that property is going to be not subject to testamentary law, it's not going to be subject to your will, but it's going to be subject to interstate law, which is your personal law, which at times can be very complex and it might land up causing a lot of chaos. Therefore, it's always preferred that a rest and residue clause be placed. Moving ahead, a joint will. A joint will is basically where a husband and wife prepare a same document, prepare a similar structured document, and preferably this document is itself a single document wherein the husband directly wills everything of his to his wife and the wife directly wills everything of hers to her husband, and in case they die together, there are specific instructions on who the property goes to. So in a joint will, what happens is the husband says that I want my wife to be secured first, and the wife says vice versa, and in case we both die, then this is what's supposed to happen with the property. Therefore, a joint will is sometimes convenient for many people and might be convenient in your case. Following a joint will, though a joint will sometimes gets a little tricky and complex because it's not straightforward and it's not it's much more intricate, that it accounts for two people's properties, and if it is like the wife is holding certain specific assets which are not shared by the husband, then it gets a little complicated because you need to make mentions of these separate items when the wife dies, that these items have to be dealt with in this manner. So yeah, sometimes it does get complicated. Generally it's not so complicated. Then executors. Now when you make this will and you die, what happens is this is just a piece of paper. Somebody has to put it in motion. To put it in motion, you need that somebody, and that somebody is known as your executors. Generally, the male person is referred to as executor, and the female person is referred as the executrix. This is a similar concept which applies to the testator's name. So if it's a male person making the will, the person is referred to as a testator. If it's a female making the will, the person is referred to as a testatrix. So in case you have decided that your brother or your sibling or your friend is to become in charge of making sure that this will is obeyed, then your friend or your sibling is going to become the executor or the executrix. It is possible to have more than one person ensuring that the will is obeyed. However, you can keep, to be safe, you can keep the clause jointly and or severally, which means if the executors want to work together, or the executor and the executrix wants to work together, these persons can work together and execute the will, or they can work individually. Supposing one of them is not wanting to work. Today they say to you that look, we'll help you out, and in case you die, we'll be in charge. But tomorrow when you die, for whatever circumstances, they change their mind and they're like, no, we don't want to be a part of it. Then the other can at least go ahead with the will. But if you have mentioned that no, they have to jointly do it, then in that circumstance, neither of them can do it on their own, which means that the court has to appoint an executor through the letter of administration, which is a tedious process, unnecessary process. Therefore, it's always preferred that a jointly and or severally clause is applied to your executor and executrix. Moving on to the next head, a life interest. What is a life interest? You can keep a clause where you mention that I want to give my house to my son or my daughter, and at the same time, though I am giving it off to my son and my daughter cannot dispose of it. That means they cannot sell this property, they cannot get rid of this property, they cannot rent it, they cannot do anything with the property as long as my wife is alive, and my wife will be permitted to use the house. Provided these conditions are met, I want to give it to my son. So this is a life interest. This is, supposing you do not want to give the property to your wife because you're worried she will not know how to handle it and she might misuse the property. Therefore, if you feel that you want to give your wife the actual premises, then you tell her, you can make a mention in the will that I want to give this property to X for their lifetime. As long as they are alive, I want them to use it. However, when they die, I want it to go to Y. It must be mentioned over here that no property can be given in perpetuity, which means that you cannot dictate terms that I want this property to go to my son. After my son dies, I want it to go to my daughter. After my daughter dies, I want to go to this. After this, I want to go to this. And you cannot make such conditions. You cannot make impossible conditions either, which means you cannot state that if A starts to fly, if he grows wings and starts to fly, then I will give the property to him. Such a condition is impossible, cannot be met, and therefore to the part of this asset, the will would be invalid. Therefore, the will would work for the other assets, but impossible conditions, the will would not be operative, and interstate laws would step in. Again, interstate laws based on religion, which get complicated at times and which require you to obtain court orders in order to establish. So it's preferred that conditions be simple, conditions be clear, conditions be not impossible. Moving on, You can also have a condition which is generally called the doctrine of I can't recall the exact name of this doctrine, but basically it is a doctrine which allows you to opt for one or the other. It allows you to opt for one or the other condition. For example, if I say that I want to give John's house to my son, or wait, let me rephrase it. I say that I want to give John my house, provided that John gives his house to my son. Now, if John accepts this condition, then this condition is met. However, if John refuses to accept this condition, the supplementary condition which says that if John refuses to accept the condition, the property goes to my son, is met. So such conditions are also accepted, and I think these are called I can't recall. I'm sorry, I can't recall. Finally, we come to specific exclusion. In this part of the video, we discuss in case you specifically do not want a person to get any inheritance because you have had bad experiences with that person, or because that person has caused you some sort of grievance and you don't want to give him some property, then you make a specific clause. That clause would be the specific exclusion clause, giving a clear reason to exclude that person, and this reason will help the judge come to a conclusion on whether or not this will was actually made wisely by the executor and whether it was made by the executor itself. So make sure these reasons are detailed and make sure they are covered really clearly, that why you don't want to give something to someone, so that the assets which you're giving to people don't get into harm's way. Finally, we move to a codicil. A codicil is a document which is an alteration of the will. So supposing in the future you get a new asset and you just want to add that asset and you want to make a simple change, you don't want to go around the whole will, then you can simply make that one asset and you can make a mention that I executed a will back on so and so date, and this codicil is an addition to my will, and the reason for this addition is because I have acquired this new asset, or I had forgotten to add this asset at that time, and therefore this is my codicil. Most people choose to completely terminate the old will and execute a fresh will and override the old will. So that is also a fairly used method. It's choice. It's based on convenience, based on choice of each individual. So it depends on you. If you would like to execute a codicil, then that's fair enough. If you would like to execute a fresh testament, you can execute a fresh testament. Coming to another interesting aspect which is not presently followed in India is a statutory will, which is something that is introduced in England, where the person who's making the will is not the person whose assets it is. So what I mean to say is, supposing you have a minor, and the minor is holding property in his capacity as a minor, then if the guardian wants to approach the court, the guardian can approach the court and make a will on behalf of the minor, provided the court is satisfied that this will should be made and the method of the will should be in the way the guardian suggests. So therefore, I could be making a will for my wife and disposing of her property in courts of England, but this is only applicable for courts of England and jurisdictions of England courts. So unfortunately this is not available in India as of yet, And that's all for now, guys. I hope this video has given you a good idea of the ingredients that are kept in a will and the things that you should look after and keep in mind. Yeah, thanks for watching again. Also, please note that on my website I do have a free will making form. This form basically collects the data that I would require to draft the will, and I could make this will for you guys for free of charge, because I'm doing this as a community service. However, please bear in mind that I do get a number of these messages, and I only dedicate a part of my time to these activities. Therefore, if you're looking for speedy remedies, it's best that you approach a local lawyer. And if you're not looking for a speedy remedy and you can wait a week or two, then you can definitely send across your will to me, or the details for me to draft your will. Thank you, and until next time, goodbye.